Southeast Radio's Business Matters with Karl Fitzpatrick.
Now, on to our next guest. The Mediation Act 2017 was introduced in Ireland to facilitate the settlement of disputes by mediation. This forward-thinking legislation is indicative of the benefits which can be derived by businesses that use a mediator to resolve a dispute. Mediator and barrister Michael Bready joins us now to highlight the benefits and to outline what the process entails. Michael, before we discuss mediation in more detail, talk to us about your legal career.
Good morning, Karl. Thanks for having me. Well, Karl, I'm a barrister. I'm based in Belfast in Northern Ireland. I'm called to the Bar of Northern Ireland and the Republic of Ireland and England and Wales. But I practice mainly in Northern Ireland. I have quite a broad practice, mainly civil, commercial, matrimonial disputes, and that's really my background, my legal background. And over time, I developed a mediation qualification, which is sort of an adjunct offering to my legal practice.
So, Michael, provide us with an insight into some of the root causes of the disputes that you yourself are advising on.
Most disputes are what lawyers would call civil disputes or commercial disputes, and they would be disputes between businesses, between service providers. If somebody owes you money and they don't want to pay it all or pay any of it, that would be a dispute. A debt dispute traditionally was the title that would have. Any disputes between employees and their employers, for example. Workplace disputes between two employees in the one business. That's also a workplace dispute that could cause a blockage. And any really dispute within a commercial scenario. So be it suppliers, if it's internally within companies, between companies, all those sorts of normal business disputes that traditionally would rely on courts. That's where I find myself.
And of course, this week was International Mediation Awareness Week, and while the role of the courts is far from being defunct, the popularity of resolving disputes through alternative means is increasing. But why is this the case?
The key advantages are, firstly, confidentiality. So if you go to court, there's a risk that it'll be reported, or people will be in court, or somebody will hear about it. So the mediation process is totally confidential. The mediator and all the parties sign up to that. So that's the overarching rule of mediation, totally confidential. Traditionally, and particularly in big civil disputes or business disputes or commercial disputes, there are lower costs involved in mediation. It's a quicker process. So you might have to wait. It depends on the type of court and the waiting time of courts. But you might have to wait up to a year, maybe 2 or 3 years to get into the court room where a judge will make that decision. So it's a much quicker process in a mediation. It will be arranged in a much quicker way. Traditionally, what's promoted about mediation is there's less conflict. You imagine if you're in a courtroom and some lawyer is asking you questions or cross-examining you, there's none of that. It's the parties who are totally in control of the whole process, are working out a way to get a resolution to that dispute themselves. So courtroom, there's a third party judge who listens to all the evidence and makes a decision. In mediation, the parties come to that resolution themselves. It's not imposed on them.
So with all of those benefits in mind, why don't all disputes try mediation?
Well, all disputes should, and in fact, in the Republic of Ireland, you're ahead of the game as opposed to England and Wales or Northern Ireland with your Mediation Act, and that introduced an obligation on all legal practitioners to advise their clients to consider mediation as an alternative to court at the very outset. And if a client decides, as it's entirely their right, not to go to mediation before going through the court process known as litigation, a solicitor has to give a statutory declaration confirming that the client's been advised. So the Mediation Act in the Republic of Ireland has really brought this to the fore and said, if you don't want to go to mediation, you have to be advised of all the pros and cons of it. And if you still want to go through the court system, you have to sign a piece of paper saying that you've been advised about this option. So why do they not all go? There's no good answer for that. Mediators should be the busiest people in the legal sphere. But people just don't know about it yet. They don't trust it yet. And they just don't have the confidence to do something different as yet. But it's changing every day, every week.
If the process starts with storytelling, what happens next?
Well, you start with storytelling. It's known as the open session, when people can tell their side of the story. Then traditionally, it depends on mediator to mediator, but traditionally you would then go into rooms, and they're known as breakout rooms or parties rooms. And then when you go in, you meet the parties after that, and you can challenge the ideas, you can discuss what has been said, you can check with each other, what are the disputes. And often, as a mediator, what I would try and do is say to each party, from listening to you both, this is what I identify to be the problems between you. And this is what I now can identify to be what you thought had been problems. Well, actually, they aren't problems. They aren't disputes between you. Sometimes if you can find points of agreement, then all of a sudden you get people closer together. So in finding out what are problems, or maybe asking them, is this a problem? Because the other side think it's a problem, and then there may not be a problem on point one, then you might just have point 2 and 3 to look at. You narrow the issues between them after listening to everybody. And the psychology of court and the psychology of mediation for parties and the humanity of it is sometimes people just don't feel they've been listened to or they've been heard. So this open session gives everybody the opportunity to say their piece and know that they've been listened to. The only rule I have in an open session is that only one person speaks at once. So there's nobody talking over each other. It's a safe place. It's a confidential place. And you just say what's on your mind.
And of course, the success of any mediation must come down to trust as well. So on that basis, how is a mediator actually chosen between the parties?
You're quite right. It has to be about trust. And as much as somebody can trust somebody they've never met or don't really know, it comes down to word of mouth. Other people say, I had a mediation and it went well, and who was your mediator? It comes down to picking a mediator who you feel is appropriately qualified, if they've got how they've trained. It might depend on their area of expertise within the law, or within workplace mediations, or within whatever company they come from. So traditionally, if you're asked to be a mediator, normally 3 names are put forward, and the parties are pick one out of those 3 names. It doesn't have to be 3; it could be 1 or 2. But normally there's a couple of options, just to keep the impartiality of the mediator at the forefront of it all. Because and then the mediator is asked to be a mediator in this dispute, and the first thing you have to work out is that have you any conflict. So if you have a conflict, you just simply can't act as a mediator, or you shouldn't act as a mediator. But when you've gone through all those checks, that builds trust with the parties, because they know that you're coming to this without any, you're coming in a totally impartial way, without any prejudice or bias towards their dispute. And that's how you build trust in the whole process. And then how you manage the process on the day of a mediation then hopefully enhances that trust that you've built already.
And at what stage do you decide that a matter might be best resolved by the courts and the mediation process would be aborted?
It might get to the point that you realise somebody might, for example, be determined not to budge on the big issue in the mediation. And what you can say it depends on how a mediator deals with that. But really you want to challenge the idea with that person. Where are you going now? Because if you can't resolve it through mediation, you're going to court. And really you want to reinforce with them to make sure they know exactly what that means. But, you can't give them legal advice as a mediator. That lawyers do that. But you can rehearse the main advantages that we discussed earlier, that, it will no longer be confidential. The costs may start to spiral. It'll take a longer time than you're going to get through today, and you're going to lose control. And sometimes when you go through that checklist of what the real advantages of mediation are, people say, right, well, okay, maybe we need to take a different stance on a point. But sometimes it just comes down to the point when somebody just says, no, I am not going any further. I am not agreeing to this. And if they want to go on to court, well, then that's the only place for them. So that's where they have to go. But it's when you've gone as far as organising a mediation, you have everybody in the one place. I do my best to make sure we leave with a positive result. It may not be a total resolution of all the dispute, but it's a positive result in that the parties are in a better position and maybe they go on somewhere else apart from court.
And finally, Michael, what do you think the future of mediation here in Ireland might look like?
Well, I think the future in Ireland has begun with the Mediation Act, and it's only going to get better and better. There'll be cases that are entirely suitable for court for whatever reason, and if everyone's going to mediation, well, then it's going to free up the court system. But it's going to, if you go to court and somebody makes a decision that you're not involved in, it might be hard to future-proof that decision. It might be hard to deal with as you're going forward in your life or in your business. Whereas if you've been to mediation, it's going to make it easier to engage with each other in the future. And the ideal position, for example, in a commercial dispute would be if for example, a business and a supplier are in a dispute and they go to court, well, they're not going to want to do business with each other ever again. Well, maybe they will stay in business with each other if they go through mediation and they both find the resolution to that dispute. So, better relationships moving forward and less clog or blockages in the courts, and hopefully happier business.
Well, if you've just tuned in, that was mediator Michael Bready, and I'd like to thank Michael for sharing the benefits of alternative dispute resolution with us this morning.
Southeast Radio's Business Matters with Karl Fitzpatrick.